All right, I think we've got everybody in now. Okay, good deal. All right, good afternoon, everyone, and thank you all for joining us for today's a month service presentation of inherited property, clearing title, deferred property taxes, and other probate concerns. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the a month of service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us, we have Ms. Cecile Carlson. Also, on behalf of our presenting partners with the Texas Legal Services Center, we have Ms. Lisa Nelson, who's going to be providing information for you today about clearing title and the probate concerns. Also, on behalf of the Harris Central Appraisal District, we have Ms. Donna Pensick, who's going to be giving you all information about uh, pretty much about the appraisal process, the various exemptions that are available, especially those related to heirs, as well as the Harris County Tax Assessor Collector's Office. We have Ms. Shay Pinkowski, who's going to be giving you guys information about the property tax bill and deferred property taxes when you've got inherited property that have had deferred taxes on it over a period of years. But also included in our partnership, we have the Earl Carl Institute, the Houston Volunteer Lawyers, and the Lone Star Legal Aid. And together we all make up a month of service. And basically, a month of service is a collaboration of all of our organizations coming together on a monthly basis and offering a variety of different workshops and resources and information to the community relative to asset building, asset protection, the maintaining of generational wealth, and community empowerment. We know that there are a lot of underserved communities that are out there that don't have access to a lot of information. They don't know where to go for available resources and or services that are available to them. And so we wanted to try to create a larger impact and reach as many people as we possibly could. So we decided several years ago to pool a lot of our initiatives and our efforts together so that we can again try to reach more people due to the fact that we do pretty much service the same community. We all have the same mission in mind as to try to help the public as much as we possibly can. So today we're going to be giving you all the information about inherited property and clearing title. This is actually kind of like the second part of issues as it relates to probate and passing and protecting your assets. The first part of the segment is about wills and estate planning and why do you need it. So that's kind of what happens before. This part is kind of what happens after someone has actually passed, whether it's with a will or without a will. What happens to that property? What is that probate process like? What happens when you've got multiple heirs that now have part ownership in a property? What happens if somebody's had deferred property taxes? What happens if you've got an heir that one heir that's still living in the property and still wants to take advantage of homestead exemption? What is that like? What all happens? So we're here to give you guys all of that information and even a little bit more. So this month there was a little change in the schedule. So the first part that we would typically do about wills and estate planning, our wills and transfer on death deeds presentation is going to be scheduled for tomorrow at 1 p.m. So join us and the representative from Lone Star Legal Aid to provide that information for you if you have the opportunity to sign up and to attend. Also, just kind of a quick note that the information that we do provide in any of our presentations where there is legal information provided, it is not to be considered legal advice. However, we do encourage you to reach out to any of our legal service partners if you find yourself in need of any civil legal assistance. In addition to that, we have the experts that are in the fields of clearing title of the tax office and of the appraisal district. So this is your opportunity to also ask questions of them as well. However, we are on a public platform. We do record the session. We do broadcast live from our social media page. So we do ask that you try to keep your questions to be as general as you possibly can so that your personal detail information is not getting out there for everybody to have access to. We want to try to protect your privacy as best as we possibly can. So there's going to be a few people that are monitoring the chat. So they will be answering your questions in the chat. Some of those questions I will review at the end aloud as well. So that way, a lot of times you get people that are asking kind of general questions in the chat. that people that are watching on social media or folks that are watching from their phone, they can't see those questions. So I do ask those questions aloud as well at the end. You do have the opportunity to also unmute yourself when we're done with the presentation and ask your questions directly of the presenter if you're not comfortable with typing anything into the chat. So do know that you can do that. If you are joining us on our social media channels, I am monitoring the comment section there. So please feel free to type your questions in those comment sections, and I'll read those questions aloud at the end as well. So we want to make sure that everybody kind of gets their issue addressed, their questions addressed, and at least kind of give some direction as to where they should go or who they would need to contact following this presentation. So do hope that you all receive the information that you intended to receive for today. We would appreciate your feedback and love to hear from you following the presentation. There's a brief uh, um, survey that pops up on the screen, and I ask you to just take just a couple of minutes to fill out that and share your story with us, and let us know if these presentations that we offer are helpful, are they beneficial, and just let us know. In addition to that, we are also planning for our 2026 schedule and what that's going to look like. So if there are any presentations that we don't currently offer that you all may be interested in, then also please let us know that as well. Without further ado, we're going to go ahead and get started because there's a lot of information that we need to cover. So first, we're going to start with the introductions, and then we're going to move right on into the presentation. So Cecile will have you, and then Shay, and then Donna, and then Miss Lisa. And then Miss Lisa, you can move right on into your presentation. So go ahead, Cecile.
Thank you, Nia. Good afternoon, everybody. My name is Cecile Carlson. I'm an outreach coordinator here at the Department of Neighborhoods. And like Nia said, we are one of the partners in the A Month of Service collaboration. Very excited and thankful for the opportunity to be here, and thankful to our presenting partners for all the important information that they're going to bring. So I'll pass it over to Ms. Shay.
All right, everyone. Hello, good afternoon. How is everyone doing? I'm going to go ahead and share my screen now so that everyone can see.
No, we're just introducing.
Oh,
and
just
then
introducing?
Listen, yes. Yeah,
Okay,
Ms. Lisa,
sorry.
you want to go first?
Wonderful. So my name is Shay Pinkowski, and I'm here with the Office of Annette Ramirez with the Harris County Tax Assessor Collector's Office. We are the office that normally is charged with the billing and the calculations of your tax bills. So whenever you receive those, they come through us. But I'm super excited to be able to be here and answer some questions and hopefully be able to assist some of you in any issues that you might be having at this time. But please keep your questions to the end just to ensure that we're able to get through everyone's questions in timely fashion. But I'm super excited to be here with you all. Thank you so much.
All right, Ms. Donna.
Hi, I'm Donna Pensick with Harris Central Appraisal District, and I work in the communications division, and I do customer service. We call it eBank, where the emails that come in for help, I work in that department, and I love my job. So later on, I'll go ahead and put my contact information in the chat. So you're always more than welcome. If you have specific properties or questions, you can email me. So it's good to be here. Thank you.
Thank you. All right, Ms. Lisa.
Hi, everybody. Thank you so much for joining us today. My name is Lisa Nelson, and I am a staff attorney at I'm a staff attorney at Texas Legal Services Center. I am one of the attorneys on the Texas Law Help team. And like Donna, I love my job too, and I'm glad to be here and address any questions you might have. I'll talk about clearing title to inherited property, as well as give you an overview of the probate process.
Okay.
And I'll also tell you how to clear title and what you should do in the future so that your property is passed on to your loved ones. And then I'll pass it over to Harris Central Appraisal District, and they can talk about property tax issues. We've been around since 1981. We're a statewide nonprofit organization that provides legal advice, advocacy, representation, and education to underserved people across the state. We have more than a dozen practice areas, and our work touches almost every aspect of civil law that impacts low-income Texans. And we're here to ensure equal justice for all Texans by educating, empowering, and representing vulnerable people while reshaping the greater legal system that impacts us all. We're going to start with the new vocabulary you need to learn about the probate process. A decedent is the legal term for a person who passed away. Testate is a person who passed that had a valid will. If someone passes away without a will, they're considered intestate. A testator is the official term for the person who is signing the will. And a will is a legal document that states how testator's property is to be distributed after their death. Estate is your stuff. It's your property, both real property and personal property that is owned at the time of death. Probate is the process of winding up a person's affairs. Administration is the legal process when there is no will. And a personal representative is a person who is responsible for wrapping up the decedent's affairs and distributing assets to the beneficiaries. If there was a will, that person is known as an executor. If there was no will, the person is known as an administrator. An heir or a beneficiary is a person who inherits through will or by law. A lot of people think that they can handle everything in an estate if there is a power of attorney. Once someone has passed, the power of attorney is void. A surviving spouse has a life estate and a deceased person and the deceased spouse's home, even if it is separate property. A lot of people think Texas is a community property state, so I don't need to worry about a will because whoever the surviving spouse is gets everything, right? That's not true. Quite often somebody will become married to someone who already owned a home, and that home would be considered separate property. A surviving spouse does have a right to remain in the home for the rest of their life, but they are responsible for loans, property taxes, and maintenance. And when you name an executor to serve in your will, they are considered incapacitated if they're under the age of 18 or they don't live in the state of Texas. It's really important to look at these practice tips. It's great to have an attorney prepare your will. You do have the ability to prepare your own will, but I'm always going to advise you to use an attorney if at all possible through AMIS. We have a lot of will clinics that can provide you with a will and other estate planning documents for free. You never want to use forms that you download from the internet, such as the LegalZoom website. Those may not be valid. They're written to be as general as possible, and there are specific words and terms that have to be in a will for it to be valid in Texas. The Texas Supreme Court has approved a will form that you can do it yourself. You can find that at our office's website, which is texaslawhelp.org. Spouses cannot have one will, they need to have separate wills. Texas allows you to handwrite your wills. I would only do this in the case of an emergency. I advised this when we were all at home due to COVID, because it's best to have a will rather than not have a will. We have instructions on our website. You can go to texaslawhelp.org and look up holographic will or handwritten will, and we will give you the specific instructions so that you know how to comply with Texas law. It is critical to keep your will in a safe place and tell your loved ones where your will is. If they cannot find your will after you pass away, the law presumes that the will has been revoked. In other words, the law is going to assume if they can't find the original, that you tore it up. The reason why it's so important to have a legally valid will is if you do not have a legally valid will, the law determines who will inherit your property. So, for instance, I don't have children. If my husband and I passed and I didn't have a will, the will wouldn't go to the people I want to inherit. The will would go to my closest family relative. The property, I'm so sorry. Property would go to my closest relatives. If you can't find a will, you can file what is known as an application for administration. You will either file for dependent or independent administration. In extremely limited cases, if there is no will, you can file a small estate affidavit. In Texas, you are required to have an attorney for almost every probate process. And one of the most important reasons why is that an attorney is going to know the best way to proceed, especially if you can't find a will. Probate assets are the property that pass to your beneficiaries through the will. That can be real property, as well as your personal property, your household items, your car, your furniture, all of those types of things. We also have non-probate assets in Texas. Non-probate assets do not, assets, I am so sorry, non-probate assets do not pass under a will. They pass in accordance with the terms of a contract. Examples would be any life insurance policies that you have, retirement plans, and payable on death accounts. If you learn nothing else from my presentation today, if you have payable on death beneficiaries on all of your financial accounts and a transfer on death deed for your home, your family may not need to probate your will. So after we're finished here or tomorrow morning, you should check with your bank, your credit union, any other places where you have financial accounts, and make sure that you have payable on death or transfer on death beneficiaries for those accounts. Then your family will be able to access those funds much more quickly than going through the probate court. Small estate affidavits are only appropriate in limited circumstances. You can only use them to transfer your home if the following conditions are met. The home has to go to a surviving spouse or child under the age of 18. You cannot use a small estate affidavit to transfer a home to an adult child. All of the heirs have to sign the small estate affidavit along with 2 witnesses that will state that everything on that form is true. You cannot use a small estate affidavit if the person had a will. The value of the assets have to be greater than the debts of the estate. So if you have property worth about $45,000, but you have $60,000 in debt, the judge is not going to approve the small estate affidavit. Also, the estate, excluding the homestead, has to be less than $75,000. Your homestead is exempt property and does not contribute to the value of the estate. For both probate of will or administration, your attorney starts the process by filing either an application to probate or application for administration. After 10 days, the attorney can schedule the hearing in front of the judge. This does not mean you go to court 10 days after the attorney files the application. In Harris County, it can be quite a few months. The courts are really backed up. The hearing is very short. It's usually between 5 and no more than 15 minutes. The attorney just demonstrates to the judge that the will is valid and that the person appointed is suitable to be the executor of the estate. If there's an administration, there was no will, the attorney has to do a little bit more to prove that none of the heirs have been left out of this process. Once you have been appointed personal representative, you will receive letters testamentary if there was a will, or letters of administration if there was no will. And then it's the personal representative's job to gather all of the assets and open a bank account for the account. This requires a tax ID number. So once you have the application, you will, once you have, the letters testamentary or letters of administration, you will take those and the death certificate to a bank, and you will open up a separate bank account in the name of the estate. Your attorney notifies creditors. Please do not think that you are responsible for your deceased loved one's bills. You are not. Those bills are paid out of what the estate has, and there is a strict legal process on how they can collect what is owed. After the creditors have been notified, then the attorney and the personal representative prepare and file an inventory. That is a list of the property that the deceased person owned as of the date of death. A lot of people think that they need a trust because probate sounds like a big, scary word. It is also a document that states how a testator's property is to be distributed at death. You can use trust to transfer both real and personal property. One of the critical things, a lot of people will get a trust off the internet and do it themselves. Trusts are completely worthless if you don't transfer property to the trust. It's just a stack of paper if you do not go through the process of transferring the property from your ownership to the trust ownership. This is why it's extremely expensive to have an attorney prepare a trust, because they have someone who will go through the process of making sure that everything is validly transferred to your trust. That's why it's not one of the many reasons why it's not a good idea to create your own trust. There are some good reasons to have trusts. A lot of people use them because they can transfer assets to a trust and qualify for Medicaid sooner. Trusts also allow you to have control after your death. If you have someone in your life who is not responsible, it might be better for them to have inherit property through a trust. Like I said, people think that they're fabulous because you avoid probate, but probate in Texas, if you have a valid will, is not complicated, and it's not that it's less expensive to go through probate than to have a trust. Okay, this is a repeat that I just said. Sorry about that. Here, now we're going to talk about how to clear title to inherited homes. A lot of people think, I just ran into somebody at a resource fair 2 days ago that thought that she owned the house because her mother had passed away and it's a family home. If you don't go through the legal process of transferring the property from that deceased person to the person entitled to the home, you won't have clear title. And if you don't have clear title, you won't qualify for any disaster assistance when we have the next natural disaster. Additionally, you're not eligible for property tax exemptions or deferrals if you're not the owner of record. A clear title means that nobody else has a financial interest in your property. It also means that there is no question of ownership and that the ownership history of a property can be easily traced. If you don't legally transfer property to a subsequent owner, the title is what's known as cloudy. This can happen when somebody dies without a will or a family doesn't manage the estate properly. The difference between a title and a deed is that title is not a piece of paper. Title is the legal right to the property. The deed is the piece of paper that conveys the right to the new owner. Real estate title is not a document. It is the strength of your ownership claim. Having clear title means that there will be no unexpected claims on the property. A deed is the document that transfers ownership to the new owner. In order to have clear title, you need to make sure that you keep your title clear. We regularly do a presentation on deed fraud. It's also available online on our YouTube channel, and I highly recommend watching it. It's an excellent presentation. What I always tell people is please file a transfer on death deed, because it's the easiest and least expensive way to transfer real property to someone after you pass away. You also can transfer property by preparing a will that meets all Texas legal requirements. It's very important to probate your loved one's estates. I can't tell you how often I run into people who think, well, my loved one had a will, that's all I need. Now everything's mine. That's not true. You do not have clear title, and you may not be able to access financial accounts if you don't probate your loved one's estate. There's a few options through the court process to clear title. If the homeowner passed away within 4 years, you should file a probate application or an application for administration. If it's been more than 4 years, you need to file an application to probate as muniment of title. And if you meet all of the legal requirements, you can file a petition for adverse possession. So the Texas law requires that you probate a will or file an application for administration within 4 years of the date of death. If you go through the probate process, the judge determines whether the decedent left a will compliant with Texas law. So if there is no will, you can file an application for administration. If it's been more than 4 years, or if the only thing you need to do is transfer title to a home or other piece of property, you can file an application for probate as muniment of title. The homeowner had to have left a valid will, and all of the heirs have to agree to probate the will. And then all you have to do is file the application for probate as muniment of title. You have a very brief hearing in front of the judge in which you have to prove that the will is valid. And then you explain to the judge, all we need to do is transfer this title. There's nothing else that needs to happen with the estate. Everything else has been settled. Then the judge admits the will to probate. And then all you have to do is record a certified copy of the signed order that from the judge, along with the will. And then once that is filed in the property records, that transfers the property to the person named in the will. Adverse possession, everybody's probably heard about. That's where if you've lived on the property for a certain amount of time, you can go to the court and the judge will award that property to you. And what it means is it's a legal principle that allows a person to obtain ownership of a property based on continuous occupation without permission from the owner for a specified length of time. If you have permission to stay at that property, you cannot use adverse possession. I had examples. I had a client at one time who everyone in the family agreed that she could live in the house. They did not agree to sign their rights over to her. So she was stuck because she could not obtain title through adverse possession. Length of time varies depending on other circumstances, but it's usually that you resided in the house at least 15 years. It has to be very clear that that is your property. Perhaps you get their mail there, you keep the yard, the grass cut, you keep everything up. If you don't want to go through the court, you can use an affidavit of heirship. That is a great procedure when the property may still be in the name of a grandparent or a great-grandparent, and it'd be far too complicated to go through probate, and they didn't have a will. But you can use an affidavit of heirship if there is a will also. And an affidavit of heirship is a legal document that gives property to the heirs of a deceased person. It's a great, easy, inexpensive way to do it. It can make it more difficult to sell the house. Title companies can be tricky about it, but it's if you're planning on keeping the home within the family, it's an easy way to transfer the house to the current family members. It's basically a family tree. There's a legal form that you can find at our website that explains how to do it at Texas Law Help. And it has to be signed and notarized by two people who knew the deceased person and their family history. It cannot be anybody who would inherit the house, but it can be an aunt, an uncle, a cousin, a longtime family friends. Those are all great witnesses. And you have to include the full legal description. The legal description is found on the deed. Do not use the description on your property tax bill. That is not the complete legal description. Once everything is complete and witnessed and notarized, you can file it in the county. You must file it in the county where the property is located. There is a filing fee that varies by county. I'm going to say roughly between $35 and $50, depending on where you need to file it. I've used affidavits twice in this presentation. A small estate affidavit is used to transfer property if there's a surviving spouse or minor children. You can also use a small estate affidavit to transfer a bank account if that's the only thing you need to transfer and there was no will. Affidavit of heirship is the best way to transfer a home to adult children, surviving spouses, or other family members that would be the ones to inherit the property. If the home is the only estate asset, it's a great way to transfer property. Once I get clear title, help somebody get clear title, I say, please, let's make sure this problem doesn't happen in the future. Transfer on death deed is wonderful. It's a simple, inexpensive way for a homeowner to transfer a home or real estate to someone else upon their death. So it could be that they had rental property that you want to transfer to a family member. You can use a transfer on death deed for that too. So a transfer on death deed does not affect the owner's rights during their lifetime. So you can still sell the property, use it as collateral, get your property tax exemptions. It is absolutely 100% your property as long as you're living. And the beneficiary does not have any rights until the owner passes away. You can also change the beneficiary or cancel the transfer on death deed entirely. I had a situation where a gentleman wanted to leave his house to his grandchildren, but they were all really young. They were all under 18. And so what I told him to do was to file the deed, giving it to his daughter, and his daughter would have instructions to sell the property and give the funds to his grandchildren. Once those children turn 18, he could revoke the current transfer on death deed and file a new one that gives the property to his grandchildren once they're adults. The deed must be filed before you pass away in the county where the property is located. So you do not want to put the deed in the safe place with your will. If you don't file it, it's invalid. A lot of people ask about ladybird deeds. Those transfer on the death deeds have been around almost 10 years. A ladybird deed has been around a much longer time. The official name for a ladybird deed is an enhanced life estate deed. Unlike the transfer on death deed, it isn't covered by a statute. The TOD is an actual Texas law. The one good thing about a ladybird deed is the person holding a power of attorney can sign it if the homeowner is incapacitated. Ladybird deeds are accepted in 5 states, including Texas. TODs are acceptable in a lot more states. TOD and ladybird deeds both avoid probate and Medicaid estate recovery. Those are, if someone receives Medicaid, typically people receive Medicaid to pay for nursing home care. Once that person and any surviving spouse passes away, Medicaid can seek reimbursement of what they spent by going through after the house through probate. If you transfer the house to your loved ones through a transfer on death deed or a ladybird deed, Medicaid will not seek reimbursement. There are a lot of differences between the transfer on death deed and the ladybird deed. Transfer on death deed is governed by law. It's governed by the Texas Estates Code. Transfer on death deed allows you to have alternate beneficiaries. Commonly, it's the surviving spouse, then a child, then a grandchild. Ladybird deed only allows you to leave that property to one person. The biggest difference and the most critical difference is transfer on death deeds does not trigger your mortgage to due on sale clause. So the mortgage can't say, oh, the property's been transferred. You need to pay the mortgage in full. A ladybird deed might transfer your mortgage and require you to pay it off because it is past it. When you do a ladybird deed, you have a life estate. You do not own the home in full. Transfer on death deed can only be filed by the property owner, so they have to have capacity to sign a deed. Ladybird deed can be transferred by the person acting as your power of attorney. This is explained in detail in the other presentation about deed frauds. Transfer on death deeds transfer greater ownership rights to the person who inherits that way. Ladybird deed does not come with any warranties. And the one thing that people are nervous about transfer on death deeds is creditors may be able to seek payment through the value of the home for 2 years after someone passes away. Ladybird deed, it might be difficult if the homeowner gives a property to someone through a deed and they only have a life estate. They may have difficulty selling that home in the future without the beneficiary's approval. Ladybird deeds have to be prepared more than 5 years before you apply for benefits through Medicaid. And TODs can be done at any time. We have a toolkit at texaslawhelp.org that gives detailed instructions and the form Just like with the affidavit of heirship, you need the correct legal description. You do not want to use the description from your property tax bill. It's confusing because the property tax bill says legal description. That's only a very short part of your legal description. So if you use that, that it will be an incomplete transfer and your deed may become invalid. What you want to do is go to the county clerk's office, to their property office, and request a copy of the deed. Like I said earlier, transfer on death deeds also protects your property from Medicaid estate recovery. We have a wealth of resources here in Harris County. Our website is available for any Texas resident. These other organizations are for Harris and the adjoining counties. So Earl Carl Property Preservation is at Texas Southern University, and it helps with any legal issues related to the home, both property you own and apartments and rental property. Lone Star Legal Aid and Houston Volunteer Lawyers can help with almost any civil legal issue. Legal Line is an amazing resource. You go through the Houston Bar Association and you can get legal advice from an attorney. They do not have any type of income limitations. Houston Lawyer Referral Service will provide you with the names of attorneys that they determine are qualified to assist you with any legal issues. And you can get a 30-minute consultation for $20. Lots of times, if you just have a few questions, you can get everything you need from that consultation. Thank you again for your time. I will be monitoring the chat and I'll be back at the end to assist you with any questions.
All right. Miss Donna, you are up.
All right. Hello again, everyone. I'm with Harris Central Appraisal District. And
Can you see the screen? You see the screen okay?
yes, did you want to put it in slideshow?
Oh. How about now?
Perfect.
Okay.
All right, thank you. So we're going to go over property tax exemptions. And I've shared before, I'm Donna Pensick with the Communication Services Department, and I work in customer service. Property taxes, they support critical local services. Texas has no state income tax. So our local taxing jurisdictions use tax revenue to provide local services, including schools, streets and roads, police and fire protection, etc. We have property tax laws which originate with our Texas state legislature, our Texas comptroller. The role of the central appraisal districts is to appraise for value. Appraise all county property, including residential, commercial, agricultural, industrial, and business personal property. And we do that at 100% of market value. And we do that as of the appraisal date of January 1 of each year. We administer exemptions. We certify appraisal rolls, allowing taxing jurisdictions to set rates accordingly. And our certification roll is basically us certifying the settled values for that year to the tax offices. And we work to keep the system fair, and it's overseen locally by the chief appraiser and a 9-member administrative board of directors. Important dates, the appraisal annual calendar. So January 1, as I shared, is our date of appraisal. Your value is based on the condition of the property as of that date. May 15th of each year is our protest deadline. Protest may be filed by this date for any value change to occur before values are provided to the jurisdictions and tax bills are calculated. Or it's 30 days from the date of the notice, whichever comes later, if your account happens to notice later than May 15th. So October, November is usually when our tax bills are mailed by the assessor. In Harris County, billing and collection is handled by local tax assessors, not by HCAD. February 1st is the delinquency date for tax bill due date. HCAD appraisals were required by the Texas Property Tax Code to be at 100% of market value. Oversight, the state does conduct biannual market value studies of the CADs to ensure compliance. Our appraisals are conducted by a process called mass appraisal, and the value is derived based on sales. HCAD is responsible for 1.9 million parcels, and we serve over 600 taxing jurisdictions in Harris County. This is just a copy of the annual value notice that's sent out when we do notice a value for the year. You'll see it has the unique iFile number and an account number, and also a link. It'll tell you where you can file a protest online. You use the iFile number and the account number to create the online user account. And the protests are based on the market value. So that is what you're protesting when you submit a protest. And you'll notice, even on the value notice, there'll be two different values. It may be the same number, it may not, but there's an appraised value. The number used in calculating the tax bills, as I shared, it may be the same value as the market value, or it may be lower because of the 10% appraisal cap for properties with homestead exemptions active on the account. Market value is the value at which a property would sell to a willing buyer on the open market. HCAD's primary role is to establish an annual market value. Protests are based on the market value, not on an appraised value. Exemptions. What are they? How can they save me money? How do I get them? Exemptions are property tax reduction or elimination for eligible property owners. Exempts a portion of the property's value from taxation. Now, this is primary residence only. It's administered by HCAD, and it's used by the taxing authorities in calculating your property tax bill. Exemptions exclude part of your property from taxation. It reduces the appraised value before your tax rates are applied. So the most common residential exemptions are our general residence homestead, our 65 or older exemption, the over 55 surviving spouse, our disability exemption, and we have several disabled veterans exemption. There's 4 types for disabled veterans or surviving spouse, and then there's other service-related exemptions. November 4th, the constitutional amendments. The Texas voters decided to approve several property tax-related amendments, including HB 9, which was pertaining to business personal property, that went from $2,499 to $125,000. ESB 4 was pertaining to the homestead exemption, and there was an increase from $100,000 to $140,000 allowance benefit. And then the SB 23 was our over 65 and disabled person exemption, and that went from $10,000 allowance benefit to $60,000 allowance benefit when you have those exemptions on the account. And this became effective for the 2025 tax year. So for our general residence homestead exemption, we use Form 1113. You must own and occupy the home as your primary residence. The documentation required is proof of ownership and a Texas driver's license with the property address on it. This provides 10% appraisal increase cap, which goes 2 consecutive years going forward. So I would have the exemption, and then it's the next year that my account may actually have a 10% cap. There's a $140,000 school tax exemption by state law, and other exemptions may be offered by various jurisdictions, including city, county, special district, and it depends on where you live. So our over 65 and disabled exemption. The over 65 exemption, you qualify for the exemption for the entire year and the year that you turn 65. The disabled exemption, you qualify for the entire year that you become eligible to receive disability. And that's benefits under the federal age, survivors, and disability insurance, or you have a physician's statement of permanent disability. The benefits for either exemption, you will have a school tax ceiling or freeze the year that you receive those exemptions. Exemptions are granted to homeowners with a general residence homestead. You're eligible at that time also for tax deferral and to pay taxes in installments without penalties. And other exemptions may be granted by individual jurisdictions. Our over 55 surviving spouse exemption, you qualify if your deceased spouse died in a year in which they qualified for the over 65 or disabled person exemption in their name. The surviving spouse must be 55 years of age or older on the date of death, and you receive all the over 65 exemption benefits. That school tax ceiling continues and is transferable, and you're eligible for tax deferral and to pay taxes in installments without penalties. The immediate residence homestead exemption. You qualify upon occupying the home. These are like for new builds or homes where previous owner had no exemption on it, and you bought the property after January 1. So you must apply for these before the first anniversary of the date the property was purchased or acquired. If the previous owner does not have exemptions or the home was never occupied, the exemption will be granted as follows. So upon approval of your application in that first year, the exemption is prorated on as of the date you owned and occupied. And then the second year is when you have the exemption for the entire year, and that year establishes your cap eligibility base year going forward. So if the home was previously owned and receiving exemptions, the previous owner's exemptions will remain for the remainder of that applicable tax year. And so you have the benefit of that exemption for that year's taxes. There is an heirship exemption and the steps for receiving the homestead exemption if it's an heir property. You use the same application form, and in section 3, as it's highlighted there towards the bottom of that section, you'll see there's 2 important questions that need to be answered. 1, is the property for which this application submitted an heir property? And 2, do other heir property owners occupy the property? So you'll answer those questions, and then along with the application and a driver's license with the property address on it, you need the following documents. 1, an affidavit establishing ownership of interest in the property. This can be a recorded heirship affidavit or Form 50-114-A affidavit. 2, you'll need a copy of the death certificates for the prior owner of the property. 3, you're going to need a copy of the property's most recent utility bill, at the address. And 4, citation of any court record relating to the applicant's ownership of the property if it's available. Veterans exemptions. We have the total VA exemption, where you're 100% disabled under their service-connected rules. We have total disabled veteran surviving spouse. We have disabled veterans exemption at lower ratings. We have a surviving spouse veteran disability transfer, and then veteran survivors exemption. Exemptions, how to apply. So you can submit a paper form application with your documents. We do have an online submission. We do have an HCAD mobile app that you can do the over 65 and homestead, and you can also email your application documents into us. Depending on when it's submitted, the processing time may take longer. So like the HCAD mobile app is the quickest and fastest, but you have to make sure the account's in your name, your driver's license must match our records as well. And it's also important to submit everything at once to avoid delay in processing. Once it's applied to your account, you'll be notified. We usually send out a confirmation letter or an email if it's through the mobile app. We also have a how-to video, which is next to our Form 1113 on the website. You go to our website, which is at www.hcad.org. Go to the Forms tab, and at the top, under All Forms, you'll see Popular Forms. And you can follow the how-to video as you fill out your application form if you would like. We do have additional helpful information and videos also on our website. And be wary of solicitations offering designation of homestead for a fee. And they also require a notary. Acquiring the exemption through HCAD is free to the property owner. It helps with your tax liability, and that designation of homestead is unnecessary. If you go on our website under Help, Consumer Alerts, there's also information on this designation of homestead alert. Each year, annually, HCAD does send out homestead confirmation postcards. It's a small little postcard. It looks like, that's what it looks like right there below. And if you receive it at the end of the year, there's nothing more that you need to do. You just make sure the information is accurate and that you are receiving the exemptions you qualify for. Typically, we mail these out in December, and it's on accounts that have a homestead exemption. So as I shared, if you get it, no need to worry. And if not, sometimes the Postal Service will send it back to us in error, and then we have to verify that that your exemption is still applicable on the account. This is just a copy of our home page on our website. You can see at the top, it has the different tabs, and then there's also different things you can look up, protest option, exemption forms. You can even make an appointment to come in person if you would like to our office. This is our contact information. Our address, 13013 Northwest Freeway, Houston, Texas, 77040. Our office is there off 290 and Hollister exit. Our general phone number, 713-957-7800. And there's our website link. And then also, if you go to this contact tab, you will find our web form that you put the information in, and you can send us an inquiry so we can review and research it for you and help you that way. So I believe that is it. So I want to thank you all, and I will repost my information in the chat. So you are more than welcome if you have a personal property, and you can email me directly and I'll be able to assist you. Thank you.
All right. Thank you, Donna. All right, Miss Shea, you're up.
All righty. Hi, everyone. Hope everyone can hear me okay. Excuse me. All right, I'm going to go ahead and share my screen. Hope everyone can see everything okay. But just for reintroductions, my name is Shea Pinkowski, and I'm here with the Office of Annette Ramirez, which is our Harris County Tax Assessor Collector. And I'm going to go ahead and jump right into it. But essentially, what our office does is we are the tax assessor collector's office, meaning that we are the department that normally handles the calculations and billing of property taxes, as well as the collection of these taxes to then disperse to the jurisdictions that are collecting them. We just recently appointed a new Harris County tax assessor collector this past year. We elected her in not this November election, but the one previous to that for 2024. So she comes with a wealth of knowledge and a wealth of good ideas. So we're super excited to have her here at the helm. But there's a bit of information here if you'd like to look that over. So our responsibilities. As a tax office, we are responsible for collecting property taxes for the over 80 jurisdictions that are collected by our department. In addition to that, we register vehicles for our vehicle stickers and registrations, as well as transferring titles of vehicles over to new owners, and other motor vehicle services like placards and issuing out special plates and things of that nature. We also maintain the voter rolls for the registered voters of Harris County. So you might have come to register to vote at some point to one of our offices. But essentially, this is what our office does. So just as an overview, the Harris County Tax Office maintains approximately 1.7 million tax accounts, which collects over $8 billion in property taxes each year. All of those funds that we collect do not come straight to us. We disperse those funds to the jurisdictions that are collecting these taxes in order to maintain their functions. So we collect for jurisdictions like the Harris County, the Houston ISD, City of Houston, the Harris County Flood Control District, along with quite a few other ones like the Department of Education, some schools. You may receive part of our statement including your MUD if you have a non-city water or emergency services district. So we really do collect for a little bit of everything, and there are quite a few jurisdictions that we collect for. Just for everyone's knowledge, I know that it was mentioned a bit earlier, but there have been quite a few law changes since this last election, including the increase of the general homestead exemption for schools, which went from $100,000 to $140,000. The school also increased the over 65 and disabled homestead exemption from $10,000 to $60,000. And Ms. Donna did expand on the qualifications for surviving spouse and veterans whose death was due to a service-connected condition. So there have been quite a few things that have been voted into existence this past election, and of course for the following year as well. So it's good to keep yourself informed and make sure that you are aware of everything that is going on. But this is what was elected on this past November. So for those of you who aren't really familiar with how tax bills are calculated and how those calculations work, the Harris County Tax Office takes the information from the appraisal district, which includes the appraisal value, any exemptions that might be applicable to your account, and we take that information in order to calculate your bill. The way we do so is we take the taxable value of your property, which would be the appraised value minus any exemptions that are applicable to you. That's your homestead, your over 65 exemptions, any disabled veterans, any disabled persons. solar power type exemptions, all of those exemptions get subtracted from the appraised value to give us our taxable value, which is the amount we're able to tax on. We multiply that by the tax rates, and each tax rate is calculated separately. So every jurisdiction that we collect for has their own tax rate. It's all unique. And the way that they determine that is through the jurisdictions themselves. Every jurisdiction has a method of determining what their tax bills are going, or what their tax rates are going to be. We receive all of that information, and then using those two numbers, we calculate for your tax bill. And each jurisdiction is calculated separately because each jurisdiction has their own requirements and abilities for exemptions. So just for your own personal knowledge, this is approximately what your tax bill is going to look like this upcoming year. Not very much has changed, but you'll be able to see the itemized jurisdictions for whichever jurisdictions collect for your account, along with any exemptions that are applicable to that jurisdiction, and the tax rates along with how much that statement is. There at the middle portion here, you would see what the total amount to due is, and at the bottom, you'll see something that we call a coupon. That coupon is a perforated third of the page that you can send in along with payment. So if you're mailing your payment, you can submit this little coupon with it in order to tell us which account this payment is going to be going to. If you bring it into an office along with your payment, then you can use this in order for us to make sure that we're collecting to the correct account. It'll bring up your account number, and we'll be able to bill you that way. But this is just in order to make things a little easier for you and so that you're able to quickly search for your account information. So exemptions, due to these recent changes, I know that a couple of you might have been here before, but our chart looks a little different now. So the average value of a property in Harris County has gone up. So the values of the properties go up. So as of this moment, we're using a $400,000 taxable or appraisal value for our example. But you can see that just the bill on its own without any kind of exemption, the tax bill ends up being approximately $8,500 for a $400,000 home. Now, with a homestead exemption, that gets reduced. So it gets reduced by almost $3,000, and the tax bill with a homestead exemption on it would come up to about $5,583. Now, whenever you get the over 65 and the homestead, that gets reduced drastically. You see a really big difference between what the only homestead versus the homestead and over 65. You see a pretty big jump there. So the tax bill for a property with over 65 in homestead ends up being somewhere in the realm of $1,500. So just as a visual representation of how important it is to make sure that if you are applicable for any exemptions, that you go and apply for those with the appraisal district, because they really do make a very big difference in how much you pay in your bill. So just be aware of that. So in addition to the exemptions reducing how much your taxes are, when you have an over 65 exemption or a disabled exemption on your property that is a homestead, you also get something called a tax ceiling or a tax freeze. And what this does is on your school, it limits the tax amounts that are collected for your school. So meaning the year you turn 65, the tax freeze comes into play. You won't really see much of a difference. But the following year, if the calculations for your tax bill require you to pay more than what you had paid the year prior, you would not pay more than what your tax frozen amount is. So you can always pay under. If the calculations provide that you pay less than you paid the year prior, you can always pay less if that's what's on your bill. But if your taxes calculate to higher than your tax ceiling, then of course you would be capped off at that ceiling as it was the year that you turned 65. So again, this applies to homeowners of property that are over the age of 65 and have that exemption on the property, as well as homesteaded properties for disabled homeowners who have that disabled exemption on their property. In addition to the tax ceiling, we also have something called a tax deferral. Now, there is a lot of confusion about tax deferral versus tax exemption. So the over 65 exemption reduces how much your taxes are based off of the value of the property. The tax deferral is a postponement. of taxes, meaning the taxes that are on your bill while the bill is deferred are still due. However, it does give you additional time in which to pay this with a reduced penalty, with a reduced interest fee as opposed to penalty and interest as you normally would be collected on. These tax deferrals are still owed. They are a postponement for as long as you own and live in the property, meaning that if you are over the age of 65, you own this property, and you decide that you would like to have the deferral on your property in order to not pay taxes, and you do not pay your taxes from the age of 65 until either you move out of the property, you sell it, you pass away, your heirs, whoever receives this property, would be responsible for the taxes that are owed since you deferred it. So those taxes that are on your bill, while you're not required to pay it in that moment and you have that postponement, they are still a required bill. They are still owed. So it is something that you'd like to keep in mind, that your mortgage company may not allow you to have a deferral of property taxes. So if you are still making payments on the property, if you do still have an escrow with your mortgage company, please consult with them first, because as a mortgage company, they do have an interest in your property whenever you are paying them in order to pay off your home. So they may not allow you to have that deferral. So please keep that in mind. Contact your bank, make sure that everything is squared away and that you're able to apply for this deferral. Tax deferrals are eligible for property homeowners, so those who have a homestead exemption and are over the age of 65, homestead with a disabled homeowner, or homestead with a disabled veteran. And again, this is something you would apply with through the appraisal district. It is something that you have to fill out a separate application for, and it's not automatic. So some folks, whenever they turn over the age of 65 and they have that over 65 exemption on their property, as you saw, if you have a property that's less than the $400,000 that's the average in Harris County, then of course it's a very real possibility that the bill ends up being zero just due to the exemptions that you have. But it's always best to verify and make sure if there is an amount on that bill, and you have a deferral, those taxes are still due. But of course, I'm sure there'll be a couple of questions about this later, but just so everyone knows, there is a 5% interest on unpaid balances. So while the tax deferral is in place and applicable, that 5% interest is the cap of which we collect interest, and that's 5% per year, as opposed to our usual penalty and interest. And as I mentioned earlier, the deferral ends upon the sale or change in property ownership. Another option for payment that we have for our over 65 and disabled homeowners and disabled veterans homeowners and their surviving spouses is something called a quarterly payment plan. Now, quarterly payments are very helpful for those who have a fixed income, who are not able to pay the full amount of their taxes upfront in the end of January. But that quarterly payment plan allows you to split your payment and your full tax levy due into 4 equal installment payments owed at the end of January, at the end of March, at the end of May, and at the end of July. And this can be applied to, again, property taxes with homestead and over 65, homestead and disabled property owners, homestead and disabled veterans, and then the homeowners homestead with a surviving spouse. So you must have this exemption and you must have it approved. So meaning you would have to submit a request in order for us to have this applied to your account. It's not automatic, but it is applicable if you have those exemptions on your property. In addition to all of the options that we have for our over 65 and disabled property homeowners, we also have options for payment for those who do not have those exemptions. So if you're just a homeowner, or if you are renting a property and you're still being required to pay the taxes, or if perhaps you own a spare parcel of land that does not have a property on it, or you have a business, we do offer payment plans in order to create those agreements. You are still going to be owed, you're still going to be owing some penalty and interest fees on the accounts. However, it is, in the case of homesteaded properties, reduced versus For non-homesteaded properties, it still collects at the same rate. However, you avoid foreclosure action, you avoid attorney's fees, so long as you're able to make that payment agreement prior to those attorney's fees being added onto the account. So we can begin as early as February 1st, which is the delinquency date for most of us. And as I mentioned earlier, so long as the payment agreement is created prior to the attorney's fees contract beginning, then you would be able to avoid those attorney's fees. And that's kind of where the importance of that comes in. As I mentioned earlier, if it is a homestead property, we do have a 1% interest per month plus the initial penalty for whenever you created that payment agreement. You are able to make it for 12, 24, 36 months, and the payment would be due prior to the end of each month. So you would have until that final day of each month in order to make that payment. And this is for all homesteaded properties. For other properties, meaning your spare lots without any property on it, or improvement, I should say, meaning your business personal property accounts, meaning additional homes that you rent out, all those taxes that you would normally have to collect for, we do still have a payment agreement that we can apply to this account. They are in the amount of 12 months, and you still pay normal penalty and accrued penalty and interest. Only difference being that versus not having a payment agreement is that you get that protection from attorneys and litigation. So just keep that in mind. If you feel as though you might not have enough time in which to collect the full amount of your payment, that you do have these options available to you. And of course, the sooner you start on the payment agreement, the better, because you avoid those additional fees for litigation and attorneys. We have several payment options. We've recently gotten a new website in order to make your payment, which is the www.myharriscountytax.net. You are able to access that through our usual website, which is www.hctax.net. You are always able to pay by mail, by phone, or in person at any of our branch offices. And you are able to make those in prior payments in all methods except for by phone. We do have a couple of payments that are a little different. So if you come into a branch office and you decide to pay with a card, whether that is a credit or a debit card, there is a 2.4% fee. Checks in person or by mail do not have a fee, but you are able to pay those at either branch or by mail. If you are paying online with an e-check, it is a 50-cent fee. And if you're paying in cash, please don't send that to us in the mail. Please come into one of our branch offices. There are 15 separate offices that you're able to come in and make that payment to. But please do not send your cash to us in the mail. Not the safe option. But we do have multiple branches, and we are here to help. So if you have any questions, or if you have a situation that you'd like to speak to me about or would like to put into the chat, as long as it's not too specific, I don't want to put in too many details out here right now. But if you need my contact information, you know I'm happy to give that to you so that we can hopefully get you guys situated. But I believe I'm going to turn this over to Ms. Nia, and that way we can get that process started for any questions. Our contact information is up here if you'd like to give us a call or send us an email. Our website also has quite a bit of information on it, so our frequently asked questions page is really popular. But yes, I'm happy to help you with any questions. Nia?
Okay, I was trying to see if we had other questions in here, but I don't see any. While we have you, Shay, I'm not sure if you went over, but the time frame or the timeline, if someone passes and say, for instance, they've been in their parent or grandparent's house for 10 years and they've never have switched the name over, and the grandparent had a over 65 exemption. What's the process for paying those back taxes and penalties?
Yeah, so I didn't really get into it just because I know that we like to talk about it towards the end, just because it is a really popular question. But the way that that works is when you have a deferral on your account, those property taxes are postponed. As I mentioned earlier, they are still due, but you have a postponement, meaning you have additional time in which to pay. But say, for instance, you were living in the property with your mother or grandmother, and the person who was on that property and had that deferral active on their account passes away. That property, once that deferral ends, you have 181 days in which to pay your property taxes with that deferral 5% interest, as I mentioned before, at that rate. After those 181 days from the deferral end date, you are required to pay the full amount of taxes with penalty and interest as they would have accrued from as if that deferral never existed from whenever that deferral originally started. So, it is really good information to have to make sure that everyone is aware. If you are deferred on your property taxes, that is a great thing. It's a really helpful tool for folks, especially if you're on a fixed income. Just make sure that your heirs or whoever inherits the property after you are aware of what the situation is, so that if they choose to do so, they can begin paying, your taxes now. We are able to take payments for taxes even if the property is not under your name. So you're able to start making those payments, before the deferral even comes off of the account, in order to avoid those additional penalty and interest fees that would not have been collected on a not deferred property. On that note, just because I mentioned it and it clicked in my brain, payment of taxes does not change ownership. So if you pay the taxes on an account that isn't yours, that does not give you any right of ownership on that property. It is a question that comes up a lot. I don't know who owns this property. It's desolate. It's just sitting there. No one takes care of it, but I go and I cut the grass and, I pay the taxes every year. Well, that's that is whatever you choose to do. That is a voluntary payment. That is voluntary work that you're putting into that property, but it does not mean that you own that property. You paying those taxes does not change ownership. And it is something that I've seen, a lot of people put a lot of time and effort and money into, and then, in the end, that does not change ownership of that property to you. So just to keep everyone in mind.
Yeah, that's an FYI for when those folks start going to the things that you see on TikTok or Facebook or whatever. Oh, come to this hotel and we'll give you lunch and show you how to get all these tax properties and things like that, and folks assume that because it's stuff that they hear online that it's something that applies to the state of Texas. And that's just not the case. So that's why we
That's
tell
not
you
the
to
case.
beware of the street committee when you're out there getting information from all these different sources or somebody that heard or saw something online or whatever, that it's not gospel. Okay. So know that when you're looking at certain things, make sure that it is for laws and things that apply for the state of Texas.
Mm-hmm. Absolutely.
Okay. I don't see any other questions here or online. That's rare that we hardly ever get any
Yeah,
questions from
it's quiet.
anybody.
Usually
I
we
feel
have
like I got
trouble
enough.
stopping on time.
Yeah, yeah.
Yeah, just
Yes,
an
this is not.
occasional query or something, but no, I haven't
Yeah,
seen anything.
that's about it. Well, that's all the question that I had. I wanted to make sure that we actually kind of went over that part because a lot of times we do come across a lot of seniors that also get deferrals versus exemptions. Oh, so since we were talking about the bills and stuff after someone passes, we get a lot of people that get confused about exemptions. They think exemptions have to be paid back after someone has passed. So
Mm-mm.
the exemption passes with the person, the tax bill stays with the house, right?
Mhm.
Did I say
Right.
that
So
correctly?
essentially, yeah. So essentially, the exemptions do not need to be paid back. That is like using a coupon at a store, which is a really crude comparison, but it works. So essentially, exemptions reduce your taxes, and so long as you're living in that property and have that homestead exemption on that property, that is correct. Now, say for instance, just because I've had this happen a time or two, your mother owns the property or your family owns a property. They're over the age of 65. They have the homestead exemption on that property and, they move. the property, they're still alive, they're still living, they just downsized to an apartment, they downsized to a townhome, but they passed the house along to you in order for you to have it under your name and transfer that property over. If your parents are not living in that property, those exemptions do not apply to you because your parents own the property. Like, I could live in a property that's technically under my mother's house or under my mother's name, and my mother's over the age of 65. But that homestead and over 65, the exemptions do not apply to that property if she is not over the age of 65 and living in it. So keep that in mind. A lot of times we'll get, HCAD will find out that, the property is not being lived in by that person who is on that exemption roll and who gets those exemptions, and they can go back 5 years, take those exemptions off. They're no longer applicable because the person who is on those exemptions doesn't live there anymore. And then those taxes that would have been exempt before are no longer exempt for those 5 years. They'll go back and change it.
So it's only the 5 years after someone passes that they can go back?
No, that's
Okay.
different. So that's for property that is, the ownership changes hasn't gone through. So like,
But it has
Donna
nothing to
might
do
be
with
the better,
your tax bill.
right? Because if the person is not the person living in the property and has that homestead is not the person who is living there. Like, say they, I had the property, it was in my mom's name, it's still in my mom's name, but my mom passes away, right? And I don't tell HCAD, and no one tells HCAD, and HCAD doesn't find out until 5 years later. It's not deferred, it's just, it has the exemptions on there. If the HCAD finds out, they can go back 5 years, taking off those exemptions that are not applicable to me because I'm not over the age of 65 and I, live in the property, but I never had the exemptions put on in my name. They can get those exemptions removed. That was going back 5 years.
But the deferral, is there a cap on the deferral period?
No, the deferral will go back depending on whenever the property, so deferrals are different. Yeah, that's specifically for exemptions. Before deferral, there's a deferral end date. And then from that end date, they have 181 days to pay however many years are due with that 5% interest, or with that 5% interest fee. But if they owed from 2000 to 2025, they owe for 2000 to 2020 to 2025. Mm-hmm. They owe for those full amount of time that deferral was on that account, or whatever was not paid from during that time that the deferral was on the account, I should say.
Yeah, and then a lot of times too, I'm not sure why a lot of folks think that once they get a certain age, they just don't have to pay tax anymore. And it all depends on the taxable value of the house as opposed to and the exemption.
And the exemptions.
And the exemption. So if you've got the over 65 exemption, which is like what, 260,000 for City of Houston or something, or 240,000. So if your house is valued at 220 and the exemption is 240, then that means you then don't have the property tax, the city property tax to pay.
That means that your exemptions exempt you from more than what your property is worth, and so you don't pay taxes. Right.
Yeah.
Which is what a lot of people get confused on, because that's great for those folks who are under that threshold. But if your property is worth more than the exemptions are, you're gonna owe taxes. And a lot of folks say, well, I don't have children who are of school age anymore. Why am I paying ISD tax? Why am I paying Department of Education tax? And it is a public tax. It is everyone who is a resident of Harris County and who owns part of Harris County pays taxes to assist that. So just because you don't have children or whatever the case may be, that's the only one that comes to mind immediately because of the fact that it's the most common kind of query of that nature that I get. We also get some folks who are like, well, I have my own insurance pays for my ambulance rides or emergency services type situations. If you are within that county, if you are within those lines of that jurisdiction, you still have to pay for your property taxes for your emergency services districts. It's a public tax, so everyone pays it as part of that residence of Harris County.
As it relates to probate issues and inherited property, Ms. Lisa, I see the biggest thing a lot of people that I've heard people say on multiple occasions is that, well, I'm my mom's only child, so the house automatically comes to me. Explain to them that there's still that process that needs to take place in order for you to get that.
Absolutely. If you're the surviving spouse or the only child, you still need to go through that process of clearing title. The best way to do that would be to go through the probate courts. But if it's been a significant amount of time, more than 4 years since your parent passed away, you can file an affidavit of heirship to transfer it.
Mhm. Okay. Same thing if it's a spouse.
Absolutely. I run into this all actually I run into both issues all the time.
Okay.
I where people think I'm the only kid or I'm the spouse, so the house is mine now, right? And it's not. The house doesn't legally belong to you until you go through a some type of process, either a court process or filing the affidavit of heirship. You have to go through that process before the house belongs to you. And then
Hmm.
after you do that process, when you file your application to get your homestead exemption and any other exemptions, you have to file with HCAD those documents to prove that you now own the house.
Hmm. I know when for married couples, um, when they purchase property, they automatically assume that they each own the house 100%. When you in fact only own 50%, your share of one property is only 50%
Yes,
when you're married. Your other 50% belongs to the spouse. So it's that 50% that you got to transfer or make
exactly.
sure that it get that ownership interest switches to, because I think you had mentioned that sometimes that there's kids from previous marriage, kids
Mhm.
that the couple may have together, and that kind of throws a wrench into just about everything as far as who actually owns
Exactly. So if
that.
if
Yeah.
you if you bought a house with your spouse and you each own it, I'm so glad you brought this up because people get confused about it. You don't own 100%. You own 50%. Your spouse owns the other 50%. So once one of the spouses passes, if you didn't have a transfer on death deed, you need to go through the court process of probate in order to own 100%.
Mhm.
And it's not automatically yours. And if the house is not community property, say you marry somebody who already owned a home, you only are entitled to live in the house for your life. Any children they had that are prior to the time that you were married are entitled to that other share of the house, which makes it really tricky.
Mm.
That's why I always say, please have a transfer on death deed and a will because it's not as straightforward as you would think.
And tomorrow's presentation is gonna be a deeper dive into a will versus a transfer on death deed and one or the other or using both. So definitely, you guys, if you can, tune in tomorrow for that presentation. That one is typically done the first Thursday of each month, but again, we had a scheduling conflict, so we had to reschedule for tomorrow. So you definitely want to go back and hear the information about that. So definitely invite you guys to all attend. With that being said, we are planning or finalizing the calendar for December, and that one should be out sometime before the end of next week. I know we've got Coffee and Conversation that's going to be coming up on December the 3rd, as well as December the 2nd. I do believe we are having a business personal property tax presentation with the appraisal district that's coming up, as well as the wills and estate planning presentation that first week in December. We are also looking to schedule a transfer on death deed clinic for December the 13th. So you guys stay tuned for more information about that as well. So, um, Cecile, was there anything else that you wanted to add? I'm not sure if she's still there, but the all the information that was presented here today, links for the various presentations, for the various resources that were mentioned. Oh, she's frozen. Um, the various resources that were mentioned will be included along with the recording of this presentation for everyone. Um, Someone has a quick question here. I added one parent to my deed and they applied for 65 plus exemption. does my parent need to complete a TOD to transfer property back to me? So,
Well, they
Oh,
would, right? If right, Lisa, they would need to do, if they want a transfer on debt deed, when that parent passes the 50%, they would have a transfer on debt deed that could transfer the whole property that she
back.
owned to them, right?
Correct.
as far
Yeah.
as ownership goes, I'm
Yeah.
not sure if that would really change anything about the exemption, because that exemption doesn't transfer onto you when they pass. So that exemption, whenever your parent
Oh, yeah.
passes, would no longer apply to you. So yes, you can transfer that 50% of the property back, but that does not transfer the exemption.
So
And
what,
the
yeah,
exemption is only on 50% of the property as well, too.
so
Right.
what you do is when it's owned 50-50, each property owner applies for their own exemption. So she may have 50% allowance benefit for an over 65 and homestead. And if she's not over 65, they get 50% when they have the homestead if they're both living there. When it transfers back to the other person solely, the following year, like if the mother moved out or passed away, the exemptions stay that year, but the next year they would need to apply to have it reinstated. And, at 100% for their homestead, but like Shay said, the over 65 wouldn't continue. Does that
Oh,
make
okay.
sense?
So she says both parents are living there with her, and then the exempt. I'm assuming that the one parent is under the age of 65.
Well, if they own 50% and there's one of them and it's community property, they would get the 50% over 65 upon approval for that 50%. Even if it's a husband and wife, if they own 50% and one of them is 65 or older, they can apply, and upon approval, they get their 50%.
They're both over 65. So
Yeah.
yes. Okay. All right. I hope that answers your question. So it seems like the consensus is yes, a transfer on death deed.
Yes.
Okay.
Yes,
But the
for ownership.
exemption, but the exemption would go away in the event something happens to both of the parents.
Yeah, people are only
Okay.
eligible for that exemption if they are over 65 or a surviving spouse that's over 55. When I was at the Earl Carl Institute, I would have clients that inherited a home from a parent or grandparent, and they wouldn't want me to do their HCAT application because I wanted to keep that exemption. And I'd tell them, you will get in big trouble. HCAT will find out.
You think they won't? They find out always.
They do.
Eventually, it'll all come to light. Don't think that you're cheating the system, because the system will get you.
Yes, it will.
And it hurts a lot more to have to pay for 5 years of taxes backwards than to just pay it all as they come.
And
You'll,
are
you'll
people able? I'm sorry. Go ahead, Miss Lisa.
Oh, I was going to say, you will lose that exemption. You will have to pay all of that back as well as penalties. And that's a lot more than the money you'll be saving until you get
Well,
caught.
for the process of a deferred for deferred property taxes and someone passes, for the heirs, are they able to enter into a payment arrangement that for those deferred property taxes? So if my mom had a property that she was had deferred property taxes for 5 years, and do I only get 180 days, or am I allowed to make up a payment arrangement to pay off those five
No.
years
So we
deferred
cannot create a payment agreement for deferred property. So if the property taxes are still in the 181 days, we cannot assist with a payment agreement on that. You can mentally think, okay, well, this is how much it's going to be after this amount of time. I need to pay this much a month, or this much every 2 weeks, or every week, depending on how your paycheck goes. And, you can mentally kind of math that out and, make it a little less painful on yourself to do so. But we cannot set up an agreement until that deferral period is over, until the 181 days is done. Once the full penalty and interest is on there, then yes, we can assist you with a payment agreement after. But
Wow.
it's going to be at that full P&I rate, right?
Wow. Okay. So have the conversations with your family members if you guys are looking to get a deferred property tax on your account, so that your heirs, if it's the intention for the heirs to keep the property, so that they'll know and that they are aware that you have now have a deferral, and all these taxes will be due 180 days after someone passes away. Otherwise, you have to wait until after, if I'm hearing it correctly, the 180 days, and then
You
and
get
then
full
enter,
P&I
and
for
then
whatever the
enter,
balance is.
and then enter into an agreement, which is a lot more money than before that 180-day penalty is up. So definitely have the
And
conversation.
honestly, if you can't pay off the full amount, even if it's, several $1,000s that have been deferred over X amount of years, it is always better to pay as much as you can within the 181 days than to let it all fall to pieces whenever the deferral end period ends. Because whatever you manage to pay at that 5%, you pay at that 5%. You're done with it. You don't have to think about it. You don't have to look at it anymore. And then, whatever is left is what gets collected on with that regular P&I. So, even if you can't pay for the full amount, it's always best to, be prepared and proactive and pay as much as you can, because that's just helping yourself in the long run.
Yeah. All right. Thank y'all very much. Appreciate you all for joining us and staying tuned with us this afternoon. Thank you, Miss Lisa, Miss Donna, Miss Shay, for you guys taking the time out of your schedule. I know that you guys got a lot going on right now, so we certainly appreciate you volunteering and taking the time. Thank you for Cecile. Also, you were running through the parking lot to try to get here this afternoon, so we definitely appreciate that. For everyone else, we hope you all have a wonderful remainder of your afternoon. I hope you are also able to join us tomorrow for the wills and estate planning, Wills and Todd's presentation that we're going to have tomorrow with Lone Star Legal Aid. So thank y'all very much. You all have a wonderful remainder of your afternoon. You stay safe, take care of yourselves, and we will see y'all next time.
All right. Thank you so much. Have a great
Thank
day.
you, everybody.
Thank you.
Bye now.
All right. Okay, let me stop the recording.